I have with me also here in our Lagos studio, Senior Advocate of Nigeria, Mr. Dele Adesina. There's been different reactions to the proposed arraignment of the CJN tomorrow at the Code of Conduct Tribunal. The Nigerian Bar Association, in a statement by the President, Paul Usoro, questions the speed with which matter has proceeded, saying it is taking a record 3 days from the day of receipt of the petition of January the 9th, and the investigation and drafting of the charges and the scheduled arraignment on January the 14th. The Nigerian Civil Society Situation Room says it is concerned that the timing of the charges, the national and international public perception, as well as optics of charging a Chief Justice of the country to a tribunal 4 weeks to the 2019 general election will be very damaging to Nigeria as a country and certainly damaging to the credibility of the elections. Let's get back to the conversation. Let me quickly get the opinion of the Senior Advocate of Nigeria, Mr. Dele Adesina.
Yeah.
What is your immediate reaction when you heard this?
Well, my immediate reaction was that of a shock, sadness, and hopelessness. The institution of the judiciary is headed by the Chief Justice of Nigeria. It's the personification of totality of that institution. And therefore, I'm unable to separate that personality of the Chief Justice of Nigeria from the institution itself. So, it is like putting the entire institution on trial. And therefore, I was worried about the implications of the whole thing, the perception of the people, the unintended consequences of such a trial, both nationally and internationally. Since I got this information about noon yesterday, I've been a little demoralized. In fact, I will not even say a little. I've been highly demoralized.
Why?
Because, you see, that institution has no alternative. It is the hope of everyone, both the common man and the uncommon man, whether you are rich or you are poor, is the last hope. And the basis of trust, the basis of obedience of whatever proceeds out of the judiciary is founded on trust, on confidence, and acceptability of that institution.
Is that institution immune to this kind of probe or investigation, or call it prosecution on issues of corruption?
Fantastic question. My answer is categorically no. The Chief Justice is not even immune to trial. There's no immunity in his favor, either by any statute or by the Constitution. But there is a procedure that has been stipulated by the Constitution itself. And I wish to remind you that we operate a written constitution, and we are running a constitutional democracy, by which I mean that things must be done according to the provisions of that constitution. There are so many judgments of the Supreme Court, the highest court of the land, to the effect that the Constitution determines the validity or legality of all governmental actions without exception. What then is the procedure I would have loved to see? Now, the procedure is very clear. Before I go to that, I listened to my colleague from Abuja. I think you call his name Mr. Ologbondiyan. Yes. The bit of him that I got is that there is a conflict between the Court of Appeal decision in Nganjiwa versus Federal Government of Nigeria that was decided in 2017 and Section 292 of the Constitution that deals with the removal of the CJN. I beg to disagree. There is no conflict at all. Why under Section 292, a CJN of the Federation or a CJ of a state can be removed through the steps stated there, either for misconduct or for contravention of the provisions of the Code of Conduct. You get my point? the steps are clearly stated from the NJC recommendation to the president, who also requires the Senate to give his own view about it. And if there is a two-thirds majority of the Senate in favor of removal, the president goes ahead to remove. That is not in any way conflicting with the powers of the Code of Conduct Tribunal to try any judicial officer or a public officer, including particularly the Chief Justice of Nigeria. But, you see, if I can draw inspiration from the Bible says that the letter killeth. It is the spirit behind the letter that giveth life. The provisions of the law are as interpreted by the judiciary, and by the interpretation and the application of the powers of the Code of Conduct, the Code of Conduct Tribunal cannot try a judicial officer until you have removed the toga of a judge or a justice from him through the instrumentality of the National Judicial Council. And don't forget, I wish to remind my friend that, sorry sir, the National Judicial Council is a creation of the Constitution, Section 153.
Well, are you saying that the due process is not followed? It should have been referred to the NJC. But is the NJC's power limited in any ways?
The NJC? Yes. I'm not aware of any limitation to the powers of the NJC. They have the administrative powers to sanction any judge after trial before them. I'm not unaware that the CJN is the chairman of the NJC, but the composition of that body is so formidable that they will not hesitate to ask the CJN to say, please, as chairman of this body, you step aside a little because what we want to consider touches you.
So it won't be a case of being a judge in his own case?
Absolutely no. So he wouldn't have participated in the deliberation. He would not be allowed to participate, even as a member. But the and deliberation on that petition is a condition precedent to this arraignment before the Code of Conduct Tribunal.
Talk to us about the process at which, when the petition came, the date at which it came, when it was filed, and when the CCB took the court, and when the arraignment date was announced. Is there anything unusual in that case?
You see, as a lawyer, I don't postulate. I deal on the facts. The petition was received about the 9th. Charges were drawn up about the 10th. An arraignment is taking place on Monday. Those are the facts on the table.
Is there anything unusual in that process?
Well, the speed, you know, to me, as an advocate that is interested in a speedy trial, I may not bother about the speed, whether it has taken 3 days or 3 months. If it takes 3 years, I will not be happy. If it takes 3 months, I may not be happy. You get my point? So I'm not bothered about the facts, the raw facts as they are.
But is there anything wrong, Mr. Additional, about that timing?
About the timing. I do not see anything wrong. But there is something wrong in sending that petition. I mean, in not sending the petition to the National Judicial Council.
Let me ask you, I mean, you've been at the bar for a while.
Yes.
Some lawyers believe that NJC has the disciplinary powers over judicial officers who err in the course of their exercise of their judicial powers and duty. But such powers of NJC is limited to the conduct of judicial officers in the conduct of their judicial functions. And they say that asset declaration is not wrongs committed at the course of exercise of judicial powers, but as a public servant.
Now I ask the question. If a general in the army commits stealing, is he taken straight to the law court with his wig and gown, with his uniform, and all the paraphernalia of his office? You see, every nation's institution demands what I call a commanding respect. And you can only give respect to an institution that you do not find a kind of limitation or interferences with. Why somebody may argue that this has nothing to do with a judicial function, but as long as he remains a judge either of the High Court or a justice of the Appellate Court, you have to remove that toga first. That wig and gown must be put down. And by the time the NJC sanctions him, and those sanctions can include outright dismissal, a recommendation for dismissal will ultimately lead to dismissal. As soon as the official involved is dismissed, you arraign him before the court. It may take time, but that is the procedure.
All right.
Justice rushed is justice denied.
Okay, let me ask Mr. Alobo in our Abuja studio. Why do you think that this case was not referred to the NJC? Or do you have information whether or not it was referred to the NJC?
I don't have any information other than what is in the public domain because I'm a private legal practitioner. I don't work for any of the government agency. But now we must also situate every file within the peculiarity. Recall what happened in 2007 during the saga of Kasinalo, the CJN, and Salami, the president of the Court of Appeal. And you know the scenario that took place in National Judicial Institute, National Judicial Council. And even in this present government, if the information is there, I was among the lawyers that stood an action compelling the government under the order of Madam or that impeachable offense for the CJN not to be sworn in as a substantive CJN. So I have tremendous love for Justice Onnoghen and for the institution of judiciary. But we must also not sacrifice the institution or the interest of the Nigerian nation on the altar of any particular office. If the Senate President, a sitting Senate President was charged before Code of Conduct Tribunal, heaven did not fall. Then there's nothing wrong charging a sitting CJN before Code of Conduct Tribunal, like what my Learned over there in Lagos have said. The only body that has the power to determine contravention of Code of Conduct Tribunal with respect is only Code of Conduct Tribunal, not National Judicial Council. So sending the case to National Judicial Council within this context like belaboring.
All right, Mr. Alobo, and I'd like to probably follow up just a moment. Mr. Alobo, let me follow up quickly on yet a very crucial one. Do you think that this process followed the doctrine of separation of powers?
Yes, it do follow the principle of the doctrine of separation of power. Because Code of Conduct Tribunal, in as much as is not expressly within the judiciary as it were, because it's a part of the executive body, but there's also an amendment to bring it under the judiciary to be subscribed under Section 6 of 1999 Constitution. Whatever it is now, in as much as there is a Court of Appeal decision, but notwithstanding the procedure that have been adopted so far, there's nothing wrong about it. We should not look at the Senate President is the head of the legislative arm. And if you look at the hierarchy, after the executive, you have the legislature before the judiciary. If the Senate President, under this present government, have been charged before Code of Conduct Tribunal, heaven did not fall.